of capacity to act independently. Not an issue before you. Then we have D, which is section 33.8. I'll come to that specifically. Let's go to E. The notice dated 15th July does not meet the threshold for impeachment set out in Article 181. And the Meru County Assembly standing orders, hence the same B, and hereby set aside an order of injunction restraining the respondents in any manner from discussing, debating, or any way dealing with the removal of from office through impeachment. These are the issues in Meru. I will revisit the issue of section 33.8. Next. So if you look at the issues in Meru, there are issues that are preventive in nature. There are issues that are seeking to stop a threat to violations, which is a complete remedy in Article 22, Article 23 of the Constitution, a threat. There are preventive issues, there are Medicare issues. They seek to prevent death. The petition before you is a post-mortem. It's a post-mortem. So that the respondents and the interviewer are telling you that why is the mortician looking at this body when the doctor also looked at it earlier? I mean, that's curious. The mortician's duty is distinct and separate from the doctor's duty. We have come here in a post-mortem to look at the Senate's acts and ask, are they compliant or are they violative? The axe has fallen. Allow me to address you on the issue of section 33.8 of the County Government Act. Number one, nothing stops multiple causes questioning constitutionality of a law. A law. Nothing stops it. And number two, particularly because the parties are not the same. The parties are not the same. The County Assembly is affected by section 33.8. And therefore, the cause against the County Assembly can very well include a challenge on that section. The Senate is affected by section 33.8, meaning the Senate, the action against the Senate can very well address that issue. Nothing stops the petitioner before you from filing a case against even the Attorney General in his capacity under the Constitution to challenge the constitutionality of this provision of the law. We are not seeking different factual findings on the same facts. We are seeking an interpretation of the law on this question. Once one court has determined this matter, one or the other, that will be an authority before the other court. That will be an authority before the other court. In fact, my Lord, the proper thing is to ask, what remedy does the law provide in ordinary litigation where a matter is filed before two courts sub judice? The remedy provides that you stay one and proceed with the other. Here we are fortunate that we are proceeding with this matter today before the matter in Meru is heard. The law does not provide for any drastic remedy than just proceed with one first. Finish it before you go to the other. That's all. So nothing turns, again, on the plea of section 33.8 against the Senate because the same was pleaded against the National Assembly. If you look at the claims in the petition in Meru, they are unique, particularly the factual ones. They are unique to the conduct of the County Assembly in Meru. And therefore, there's no way the Senate would have been made a party there. And if you look at the allegations before you, the factual allegations, they are unique to the conduct of the Senate through its foremost officer, the Speaker. So that should, by and large, dispose of that matter. Can I get a reminder of how my 30 minutes? I have no intention of saying anything more than my 30 minutes.
Yes, 23 minutes.
Thank you so much. Allow me to deal with now the issue of whether this court has power for merit review. Again, it's the way we read authorities. I think that is the problem. Let's go to the Sonko case that everybody has cited. You'll find it in volume 10 of the petitioner's documents at page 345. Volume 10. Yes. Volume 10 of the petitioner's documents at page 345.
You have a 10 and a 10A.
We have 10 and 10A, yes, they are both authorities.
So you want 10?
10 now, 10, yes. Thank you. That case is at page 345, and that case will help me deal with two issues. So let me start with the issue of whether this court has power for merit review. I'm going there. I want to start by referring this court to page 384. First, let's look at paragraph 148 of that judgment. Let's look at how the issue is framed by the Supreme Court. How the Supreme Court frames the issue. Whether, yes, page 384 or now. Okay. Yes, let's look at how the issue is framed. Whether the charges were substantiated to the prescribed standard to warrant the appellant's impeachment. That issue as framed is a merits review issue, the issue itself. Because, my Lord, how else can the court answer that issue without asking, was charge A substantiated? Was charge B substantiated? Was charge C substantiated? That's a merits issue. So the Supreme Court frames a merits issue. Let's go to paragraph 149, where the court looks at the Nyaga Wambora case that my colleagues have multiple times referred to. Again, the court approves of the standard in Wambora, that the standard is neither beyond reasonable doubt nor on a balance of probability. Noting that the threshold for removal of a governor involves gross violation of the Constitution, we hold that the standard of proof required for removal of a governor is above a balance of probability, but below beyond reasonable doubt. Again, the court is setting a standard for merit review. The court is setting a standard for merit review. Go to the next paragraph. The Court of Appeal in the above case also affirmed the elements identified by the High Court as constituting proof of the charges of gross violation. Number one, the allegation must be serious, substantial, and weighty. Again, once you begin looking at whether this allegation is substantial, serious, or weighty, that is merit review. That's not process. You are weighing the allegation. Then finally, page 385, paragraph 152. Page 385, paragraph 152. We maintain that the High Court received and evaluated the evidence presented to it in support and in rebuttal of the four charges. When a High Court has received and is evaluating the evidence before it in support and in opposition to the charges, is engaging in merit review. The court continues, the Court of Appeal re-evaluated the evidence before coming to its own independent determination. Again, merit review. To the principal question, can this court engage in merit review? The Supreme Court, by framing the issue as such and analyzing it as such, answers that question in the affirmative. Again, I want to ask, you have a Supreme Court decision before you. The respondent, the IPs are not telling you, what do they want you to do about these things I'm reading? At least they are my witnesses, I am not formulating them myself. These are edicts of the Supreme Court. The answer is, they have to live with it, that this court has jurisdiction for merit review. So to my learned colleague, Mr. Mukele, who said he was shocked that I said this court can engage in merit review, my answer is it was not me. I was restating the law as enunciated by the Supreme Court. He should not begrudge me. Now, to the question whether the petitioner did not raise, we restrained ourselves from objecting at all. You notice we never objected even once when they were responding. And I hope my time has been frozen, because I don't think that's an objection, but let's see.
My Lord, in that case, the court is principle governing a process of impeachment for removal of accountable. My Lord, you know that country was never had it partially.
Let's now put my conduct into question.
Just a moment.
My Lord, when you look at paragraph 164,
Yes.
the court correctly observes that the mandate, the removal of a governor is both a constitutional and political process.
It's merit.
The mandate of the courts is restricted by the doctrine of separation of powers to determine whether individuals' rights, dignity, and fundamental freedoms are being preserved and protected in the process without usurping the powers and functions of the legislative branch of government.
That's correct.
Now,
That is the law.
Counsel, this is an extremely spicy case. It's a very, very case. Counsel Ongoya.
Yes.
Just a moment. Let me speak to you.
Yes.
You read 161 Roman 4. Please now read Roman 8.
Yes.
The grounds for impeachment and removal from office must be substantiated. The standard of proof is intermediate. That is, above a balance of probability, but below all reasonable doubt. And the proof of any one of the charges is sufficient to discharge the man of office. My Lord, I wish to clarify. And that is the role of the Senate.
Now,
When the Supreme Court states paragraph 161(8), it is the role of the Senate to substantiate just one ground. Nowhere does the court say it is the role of the court to find a ground substantiation.
now go back to paragraph 152.
Is not on there.
Now, there's a very famous phrase, because this is cited quite a lot in constitutional petitions, as to what perhaps the trial court is the High Court, the first appellate court, the Court of Appeal, and then what the Supreme Court can do. It starts with "we cannot." It's in somewhere in the middle of 152. We cannot.
Substitute ourselves into the two courts and take up the roles of analyzing the evidence afresh for that time.
Now, if the Supreme Court is saying it cannot reanalyze the evidence, who analyzed the evidence? We maintain that the High Court received and evaluated evidence presented to it in support and in rebuttal. The court evaluated that evidence, coming to its own independent determination. rebuttal to a rebuttal. You're not objecting on a point of law, you're objecting to your interpretation of a Supreme Court decision. It is not as though you are saying that perhaps it had been a complete misquote, it had been overturned, etc. Secondly, and I did state this on Friday, there was a tactic that Council Ongoya invited the court to highlight and identify of breaking up their flow. Now, they did not object. Throughout your session, they waited. But let's do it differently. Let's go to paragraph 149. Yes. So the Court of Appeal in the above case, that is Wambora, which has been cited by your side extensively, the Court of Appeal, so it starts halfway down. The Court of Appeal in the above case also affirmed the elements identified by the High Court as constituting proof of the charges of gross violation of the Constitution or written laws as follows. The allegations must be serious, substantial, or weighty. There must be a nexus between the governor and the alleged gross violations. The charges framed and the particulars thereof must disclose a gross violation, and the charges framed must state with a degree of precision the articles or even sub-articles of the Constitution or the other provisions of any written law that have allegedly been grossly violated. That is the standard that was affirmed by the Supreme Court. It is not going to change. How that is interpreted is not a ground for an objection. It isn't.
Precisely, when you read what you're...
No, what you're doing is you're rebutting a rebuttal, and that is not proper. Yes, now I have to go to the sanction. Counsel, I'm going to fine you Kenya shillings 10,000. Please remind me of your full name. The court had previously warned counsel as to unnecessary and non-legally founded objections that have the effect of interrupting the flow of opposing counsel's submissions. This was done on Friday after repeated objections elongated the highlighting, which should have concluded on that day, but which
Sorry, my lord.
was spilled. Sit down.
Sorry, my lord.
Sit down.
Never.
I'm giving a ruling. You do not. Yes, Mr. Kirimi, rise. Yes. Tell me why, where in practice, when the court is giving a ruling, do you interrupt the court?
My lord, our sincere apologies to start with.
No, just give me a precedent. Give me a precedent. When did we start interrupting the court giving an extempore ruling?
My lord, with a lot of ability, I thought perhaps we should persuade you otherwise, because
You can then say after the ruling, after the extempore, you can then invite me to review. But you don't rise as I am giving the ruling and just start talking.
Lord,
Counsel,
we are sincerely...
no, counsel. just listen to me.
Listening, my lord.
There is something that is happening to practice, and I think it is very unfortunate. It is very, very unfortunate. I practiced for 16 years before I became a judge. I have never seen, in 16 years, I have never seen anyone interrupt a ruling being delivered extempore. You wait until the end, you say most obliged, and then you say we wish to apply for review, stay, whatever it is, after it has been delivered. Let me give you an example, Councillor Kirimi, so that you can understand where I'm coming from. Assuming that a judgment was being delivered by a magistrate in a criminal matter, and you can tell when judgments are going in a particular direction, do you then just stand and just start talking over the magistrate? No. No, you don't do that.
Sorry, my lord.
Now, so you've also attracted a 10,000 as well. So let's
My lord,
proceed. Sit down, please. Let me finish my ruling. If you want me to do anything, you will make an application after I've finished my ruling. Yes. So the court had previously warned counsel as to unnecessary and non-legally founded objections that have the effect of interrupting the flow of opposing counsel submissions. This was done on Friday after repeated objections elongated the highlighting, which should have concluded on that day, but which have spilled, that's where I reached, which have spilled over to today. Counsel Alex Mbaya rose on an objection that was in substance a rebuttal of the submissions in rebuttal that were being made by counsel Elisha Ongoya. The court gave counsel Mbaya time to articulate, but it became clear what his contention was, is that counsel Ongoya had misapprehended and misapplied the referenced Supreme Court judgment, and in particular the dicta on merit v. process review. That is not an objection, and consequently it is fit and proper that counsel Alex Mbaya be fined Kenya shillings 10,000 to be paid into the court by close of business 28th February 2025. Separately, and as this court was delivering its extempore ruling as above, at the point the ruling had turned adverse to counsel Mbaya. Remind me your first name?
Last name is Kirimi.
Yes, so it's
name is David.
Kirimi?
Kirimi David.
David. Thank you. Council Kirimi David rose to his feet and called and began to address the court in opposition of the court's extempore ruling. The court invited learned counsel to cite any authority that permits an advocate of this court to interrupt the delivery of a ruling in opposition of the same, rather than waiting for it to be completed, concluded, and taking the necessary action orally or in written application. Counsel was unable, and consequently this court fines him Kenya shillings 10,000 to be paid into the court by close of business 28th February 2025, dated, signed and delivered on this 24th day of February 2025, 19:06 hours. Yes, Council Kirimi. Yes, yes. Now you can rise.
Yes, my lord. My lord, first and foremost, I wish to apologize to the court and to my learned friends in this court.
Yes.
For perhaps what the court did not understand why I was rising.
Yes.
My lord, I didn't even speak. But my lord, I felt perhaps with a lot of humility, maybe the court did not look at the objection by my friend to be in good faith, which I don't think his objection was ill-intended or meant to obstruct our colleagues in their line of submissions. My lord, my intention was purely to request you for an indulgence. And to apologize, my lord.
Yes.
What perhaps has irked the court or annoyed the court.
Well, the court is not irked or annoyed. The court is confused as to when we started doing this. We see this on American telenovela, where counsel just shoots to their feet, the judge is talking and they interject. That's not how we do things in real life. Now, yes, sorry, have you? Yes, just proceed.
Thank you, my lord. And mine is to sincerely say that that was not the intention to obstruct your lordship or to appear disrespectful of this court or your lordship or of our colleagues in this humble profession. And my lord would be kindly beseeching you to consider the orders you've just given. With a lot of humility, your lordship, I urge you to kindly review them and set them aside as we finalize the hearing of this petition, so that your lordship doesn't appear to any party that maybe were gagged or orders were issued, the court was annoyed, and my lord, but we've taken the lesson that the court has given us, has reminded us. Your lordship, I wish to tell you that whether we are appearing before you or before any other court, the lesson the body does as well. Thank you very much.
Councillor Ongoya, do you have anything to say?
Thank you, my lord. I also wish to send apologies to the court. And also wish to point out
Yes.
that my objection was not ill intended. A lot of my expectation was that if this honorable court found that my objection was not merited, which was raised in good faith,
Yes.
that this honorable court would just overrule it and probably give directions as
Yes.
to what it would consider an objection on a legal issue. My lord, you remember last week, the objection that I raised was a legal issue, which this court upheld,
Yes.
and I also expected that this objection was a legal issue,
Yes.
which probably this court would have upheld.
Yes.
And therefore, my lord, whereas I, without any reservations, apologize to the court,
Yes.
and also seek that this court review its orders, I urge the court to make a finding as to whether it is open for the respondent and the interested party in opposition to the petition to raise any issues at this point which they consider may be misleading the court, because my lord, what we are doing is we are trying to help the court to come at a fair and just finding. So that, my lord, justice can be done in this case. My lord, you are always told that cases are not ours as counsel.
Yes.
Cases belong to clients. But as counsel, we are duty bound to do everything under the law to protect the interest of our clients. And sometimes counsel can go overboard in
Yes.
protecting those interests. Without, my lord, I apologize
Yes.
to the court and probably to counsel if they feel that the objection was without any merit. I
Yes.
seek the court's directions. I'm most obliged, my lord.
court, I've heard the oral submissions by Counsel Kirimi and Counsel Ongoya, and it is undoubted that they expressed their heartfelt apologies for their respective interruptions. Consequently, I find it proper to review downwards the fine for each to Kenya shillings 5,000 each, to be paid on or before close of business 28th February 2024. That's 24th February, sorry, 2025, my apologies. 24th February 2025, 19:15 hours. Beyond that, if you are still aggrieved, there are options available. Yes, Counsel Ongoya, my apologies. Just a moment, Counsel. Just a moment. Just a moment. Please take your seat. Counsel Kirimi, and no, please don't rise. We are still colleagues in this profession. It's just that I moved from there and I now sit here. You will recall, perhaps in another matter, you saw myself and my former deskmate, literally a deskmate, where I enforced the rules of the court, not because of myself, but because there is some dignity to being an advocate. There's a way we are supposed to behave, beyond the wearing the fancy suits. There's a way that we are supposed to behave, that someone seated at the back of the court can say, those are advocates, hao ni wakili. That expectation can never be diminished. So it is nothing personal, it is the rules. And believe me, you are living in a golden age of this, as Counsel Ongoya can confirm, because I think he's done more than 20, I've done more than 16. In days gone by, this would have been very different. There are cells at the bottom. That's what used to happen. I recall on the day of my admission, we were obviously very excited. We were threatened. A court assistant came out and said, if you guys continue making noise, all of you will go down to the basement. So it is not that I am irked, I am angry as an individual. I am trying to maintain the dignity that makes being an advocate special, that makes court proceedings solemn, orderly, and very somber, in a sense. Counsel Ongoya, you are at 27:59.
That's okay. I'll see. There's one issue that was raised by the respondent, my last concern, that all these issues about
found in two places. One is volume 2 of the petitioner's documents at page 16, where you will find the program of the Senate for the hearing. And the time set aside as 11 a.m. to 11:30 was for preliminaries, but those preliminaries were prescribed. A, recital of the mandate of the Senate, rules of procedure and hearing program. That is by volume 2, page 16. Yes, so you see A, recital of the mandate of the Senate, rules of procedure and hearing. B, introduction of the members of the county assembly representing the county assembly and their council, if any. C, introduction of the governor of Meru County and council representing the governor. So the issue called preliminaries in this program is defined by the schedule. It's not an open-ended generic use of the word preliminaries. The second place where the answer to this would be found is in the Sonko case again, which is in volume 10, but this time around I'm looking at page 380, paragraph 132 that my colleague referred to. I'm trying to recollect who in particular referred to it. At the beginning of the hearing, the appellant raised a preliminary objection to the effect that the issue before the Senate was sub judice, as they were also the subject of some 4 active court cases, that there was a conservatory order issued in ELRC petition number 35 of 2020 prohibiting the County Assembly and the Senate from proceeding with any motion for the removal of the appellant from office. The Speaker, in a reasoned ruling, directed that the objection be brought as part of the evidence to be presented during the proceedings. So the Speaker has already ruled that these issues are not raised as preliminary issues, that they should come out as part of the trial. Yes. And therefore, for the same Speaker and the party supporting him to come here and say that we were wrong to raise them as part of the trial, that is disingenuous. But more importantly for me, we brought to this court's attention the fact that these orders were brought to the attention of the Speaker administratively by letter in advance of the trial, by the formal response of the governor in advance of the trial, by the affidavit of the governor in advance of the trial. So that to say that these issues were raised belatedly, or that the governor and her council acquiesced, as my learned colleagues refer to it, is not supported by the evidence on record. There can be no clearer protestation than the letter by counsel for the governor, than the response by the governor, by the affidavit in support by the governor, all of which got to the Speaker ahead of the trial, protesting this trial, and eventually by in the closing submissions. Now, if you look at that trial process that we have looked at, as I close, first page what? You'll notice that at that trial, you've got page 18. This is there. So at page 16 of volume number 2, as I finish, you'll notice that there were 2 hours. There were 2 hours that had been set aside from 4:30 p.m. to 6:30 p.m. deliberations by senators. And the question will arise, my lord, so what were the senators supposed to deliberate on before voting? Because you look at it, after 6:30 then there is voting. I submit to you respectfully that all these matters, including whether the matters are sub judice, whether the house is barred by a court order, were to be considered as an integral part of these deliberations before voting. And therefore that the conduct of the Speaker in giving 3 minutes for this process, and that doesn't mean being taken away by the noise in the Assembly, the loud consultations, trying to be politically correct to the Senate, the loud consultations in the Senate, therefore took away that opportunity for these matters to be considered, and it was purely within the Speaker's domain to ensure that he upheld this time so that the governor has the benefit of consideration of all these matters. Allow me to admit my colleague, Mr. Mutuma, to pick up from there. And my apologies, my lord, you notice my voice is very bad because I have a bit of a cold. My colleagues here have taken the risk voluntarily of sitting next to me.
Yes, my lord, I will not exhaust the 30 minutes because much has been covered by my learned senior. I'll just address you on some of the issues that have not been addressed. One, in response to my learned friend Mr. Mukele's submissions, I wish to state that Article 19 and 20 of the Constitution demands of a duty bearer to ensure that any right under the Bill of Rights is enjoyed to the greatest extent. We submit to your lordship that it's not just a matter of crossing all the T's and dotting all the I's. The duty bearer, in this case being the Senate, has an obligation to go out of their way to eliminate any visible obstacles that may hinder the enjoyment of a right that has been provided for. Especially if that right is a right under Article 25 that cannot be limited.
Yes.
Your Lordship, the act of the Senate to limit the time for the senators to 3 minutes to debate such a serious motion that has serious implications against the rights of the petitioner does not sit well with Article 19 and 20, because that act in itself limits the enjoyment of that right. In the same breath, Your Lordship, limiting the governor's response to 2 minutes equally amounts to limiting the right to a fair trial that does not sit well with Article 19 and 20 of the Constitution.
Yes.
If there are obstacles to enjoyment of a right, what should have been done, Your Lordship, and nothing prevented the Senate from doing that, is to move a motion to extend the time. That would have then promoted the provision, the application of Article 19 and 20, because then it would have extended the application of the right to a fair trial.
Now, let me just pause the time.
Yes, Your Lordship.
We are clearly, all the way up to the Supreme Court, there are clearly matters that are internal to even quasi-judicial bodies that the courts do not interfere. Should this court be making value judgments as to time? 3 minutes is bad, 5 minutes is good, in the circumstances. And not having, sorry, let me just complete.
Yes.
And not having the benefit of understanding the order paper and any other materials that are likely to come up.
Your Lordship, an answer to your question lies at Article 50,
Yes.
2C, that a person facing a trial, such as the governor in this case, has a right to have adequate time and facilities to prepare a defense.
Yes.
Again, Your Lordship, when you look at the case of Pinnacle Projects Limited, which we have annexed in our list of authorities,
Yes.
it talks about reasonable time. So in your merit and process review, Your Lordship, you would then have a duty to determine whether 3 minutes shared across over 60 senators, which translates to less than 3 seconds per senator, is by whatever standard reasonable or adequate. Once you find that it is not reasonable, Your Lordship, and reasonable is in the ordinary interpretation of the ordinary person, then you should come to the conclusion that there was a limitation to the right to fair trial. Your Lordship, allow me make my comments in respect to the video that we watched, KM7,
Yes.
because again, Council Mukele told court that it is very clear that the Speaker gave time to the governor to respond, and she declined. Your Lordship, first, Senate is a house of records. Those records are stored by way of Hansards. We have not seen anywhere where the governor is recorded as declining to make her remarks. If she did, it ought to have been captured. In the absence of anything in terms of record, if there is any doubt, then, Your Lordship, that doubt can only be given to the benefit of the person who alleges that their right has been violated. Again, Your Lordship, we all watched KM7. Clearly, Your Lordship, you can see just before the Speaker gave the Governor an opportunity to speak, there were what they are calling loud consultations, which Council has admitted were commotions. That is not in dispute, Your Lordship. The Speaker proceeds to switch off the microphone, explaining why we can now not hear the loud consultations. I ask the court to take judicial notice of that aspect and be guided by the preceding paragraphs of the answers, which confirms from the mover of the motion, Honorable Aaron Cheriot, that in light of members having chosen to behave in a disorderly manner, even the mover of the motion himself was unable to make a reply. If the majority leader is unable to address the Speaker, a member of the Senate, a ranking member of the Senate, how then was it possible for the petitioner to make her remarks? Your Lordship, on the issue of sub judice, it has not been denied that a letter was written by the petitioner through advocates bringing to the attention of the Speaker of matters sub judice and the court order. The Speaker was not even courteous enough, Your Lordship, to respond to that letter or even make reference to that letter. None of the parties has come out to say indeed there was reference, or rather there was response to a letter, or there was in any case a determination by the Speaker on that question. We therefore fault the Speaker for failing in his duties and therefore violating the governor's rights. Your Lordship, there was only one opportunity for the senators sitting as judges to address themselves on this question of sub judice and the existence of court orders, and that was in the 2 hours set for the senators' deliberations. Taking away that crucial role from judges denies them an opportunity to interrogate the facts and render judgment, pushing them just to have one role, that is of voting. And you have seen senators, Your Lordship, protesting that very act. We have demonstrated to court by providing exhibits of 16 senators protesting that fact. Your Lordship, you were then told by Council Murerwa and Council Mbaya that you risk upholding the contempt of court ruling from the High Court of Meru because there is a risk that the Court of Appeal may overturn that finding. Your Lordship, this court can only apply facts as they are, not as anticipated. You cannot be asked to act in speculation. As we speak, there is a factual finding by a court of competent jurisdiction, and therefore that issue is not open for further interrogation. Should the Court of Appeal, in the unlikely event, overturn that finding, then we'll cross the bridge when we get there. And there is no shortages of remedies. But you cannot be asked to anticipate the decision of the Court of Appeal. There is no stay. There is no contrary finding to that effect.
Yes.
Your Lordship, on the question of whether you're sitting here for merit or process review, that is a question on jurisdiction from where we stand. Jurisdiction, Your Lordship, is conferred by law. It is not a matter of interpretation. So, when we go back to the Constitution, the grand norm, Article 22 is very clear, Your Lordship. Allow me to read the Lordship. That one of the remedies available in a constitutional matter such as this one is an order of judicial review. So jurisdiction has been conferred exclusively to you, Your Lordship, to issue an order of judicial review. There are three main remedies under judicial review: an order of prohibition, an order of mandamus, and an order of certiorari. An order of certiorari, Your Lordship, is an order that comes out after a merit review. So Article 23, 3F confers to you that specific jurisdiction. And if that is not enough, Your Lordship, because jurisdiction must be conferred by law, Article 165 again, which is very specific to your jurisdiction. Article 165, subclause 6. The High Court has supervisory jurisdiction over the subordinate courts, over any person, body, or authority exercising a quasi-judicial function. Now, Senate was a body exercising a quasi-judicial function. Article 165(6) gives you supervisory jurisdiction over Senate. Your Lordship, how else are you supposed to exercise your supervisory jurisdiction if it is not by a merit review of what they did? We submit, Your Lordship, that the law has conferred upon you the right to merit review. Thank you, Your Lordship. You have also been given a number of authorities which have been misquoted and misapplied by counsel, trying to persuade you to find that the right to a fair trial under Article 52 is only available for an accused person in a criminal trial. Nothing can be further from the truth, Your Lordship. The Moses Wetangula Masika case, Your Lordship, for example, is very distinguishable from the case before you. Why? The rule on double jeopardy in that case was not being applied in light of Section 33(8) of the County Governments Act. We're not even asking you to apply Article 50(2)(0), hook, line, and sinker. We are only asking you to compare Article 50.2.0 with Section 33.8. So we are not saying that the rule against double jeopardy is applicable in all trials, whether criminal or quasi-judicial or quasi-criminal. It is specifically on impeachment cases. Why, Your Lordship? The Moses Masika case is a case that did not require any party to take a plea. Therefore, there was no one accused by dint of Article 52. You had a claimant and a respondent. There were no specific charges against any individual in an election petition. In this case, Article 52 talks about an accused person facing a trial. Now, it has not been disputed that the petitioner was facing a trial.
Yes.
None of the parties has disputed that fact. It was also not disputed that the petitioner was accused of some charges qualifying her as an accused person. Therefore, one cannot lift the holding in the Moses Masika case, an election petition, which is to a larger extent a civil matter, and replace it with a trial of a governor, like in this case. On the same issue, Your Lordship, when you look at the case of Moses Wetangula Masika, and I've forgotten the citation of the other case where there was a disciplinary action, what was being challenged by the two persons were processes in two different forums. The court forum, where an election dispute is determined, and subsequently a criminal trial that now is based on the outcome of an election petition.
Yes.
Similarly, in the other case, I think it was the LSK case, where there was a disciplinary action, an internal disciplinary action. Then as using the outcome of the disciplinary action, criminal charges were preferred in a different forum. Now, our issue is quite different, Your Lordship.
Yes.
We are talking about a process in the same forum, based on the same set of evidence and facts, seeking to persuade the fact finder, in this case the Senate, to arrive at a different outcome. So the rule on double jeopardy in this case must be applied strictly and uniquely to the case before you, not compared to other processes that took place before. Lastly, on that issue, Your Lordship, is that in an election petition, there are no personal or individual penal consequences against any person. The outcome of an election petition is that the results are either upheld or nullified. End of the case. If there are instances of electoral offenses, the court then will direct the necessary agencies to take up the matter and prefer specific charges based on a finding of electoral offensive or malpractices.
Yes.
Now, if the governor is found guilty by Senate, nothing prevents the DPP from taking up the matter and charging him or her in a criminal trial. So the rule to double jeopardy would not apply in that instance. But in this case, the same fact finder, based on the same facts, based on the same evidence, cannot be invited twice to look at the same issue, because that would amount to breaching the right to a fair trial. Having said that, Your Lordship,
Yes.
it is our submissions that the respondents, apart from blanket denials, have not been able to rebut or controvert any of the evidence that has been adduced by the petitioner in support of our case. We humbly request you to find in favor of the petitioner and grant all the relief sought. We humbly submit. Thank you, Your Lordship.
That is the conclusion of highlighting. Thank you, parties. Thank you, council, for attending this highlighting. You've been here in physical since 12. You only had a 30-minute health break at some point, but I'm constrained to ask you to be with me for a little bit longer because it's keeping that I need to give directions on. The first, I think we have already agreed. I've been writing so long, I've run out of ink. Nana, just give me any color. Thank you. So the petitioner shall file the Hansard of Council Ongoya. Might be the date?
9th October 2024.
9th October 2024 with two comments made by senators in the August House referencing the proceedings. Is it really 9th? Can't, and we're not talking about the same ones. It can't be 9th of October. There was a Hansard. If you don't have it, it's fine. It is the one for. There was a discussion during the debate on the impeachment of another state officer. Of another state officer, and there was a reference to the impeachment of the petitioner hearing. So it could not have been 9th. 9th of October. Sorry. I wrote August. Sorry. 9th of October 2024, with respect to the comments made by senators in the August House regarding the process of impeachment impugned herein. So that's by end of day today?
Correct.
End of day today. Other parties to download from CTS. The parties opposed shall have limited leave to file written submissions of not more than 5 pages on the question of the Meru High Court ruling dated and delivered on 13 February 2025 and its applicability or otherwise to the present case. Other parties to download from CTS, and the parties opposed shall file by close of business 25th February 2025. So those two we had agreed. There is then the issue of the videos. Perhaps two of you on the side opposed can, in very, very brief. Yes.
My Lord, before we address the question of the videos,
Yes.
in our index of annexes, we have the videos of all the public participation meetings in order for the favors and the videos in support of the impeachment charges.
Yes.
So we will equally be inviting the court to watch those videos.
If you've put it as evidence,
Yes.
I'll have to go through it.
Indeed, my Lord.
Rest assured of that. I don't think there's been an objection from those in support, from the petitioner and those in support. The sticking point is those links. And what then happens if I want to expand? So maybe two of yourselves could address. By expanding means there are other sources, public sources that have.
I already have something, but I am one of those judges who wants to hear from the council and the parties. So if the link doesn't work, what is your take?
On the part of the assembly,
If their links doesn't work.
that we are limited to what parties file in court. We file our videos, the certificates in that regard, and we would suggest that the court does not go beyond what the parties have submitted to the
Council Ongoya?
This is consulting because, to my recollection, we endeavor to get all our videos from Senate's own website. So our videos are actually picked from Senate's own website. I just confirm there was any that was not picked from there before I can confirm. But I know we endeavor to just pick from Senate's own website because for obvious reasons we need one to deal with authenticity issues, but then we wanted to put Senate with its own links. Not only DKM1, if I was separate, so that all the other links are picked from the Senate's own website. So they are Senate's own videos, which get the authenticity is landing in that.
Yes.
Your Lordship, if I may,
Yes.
in the same regard, then if the video is not picked from the Senate website, or that the allegation in the certificate is that the video was taken from the Senate website and it is not, then I also pray that the same be disregarded, Your Lordship.
I'll deal with that because you've submitted extensively on that. So I've heard you. This is my direction on that. The court shall not, in considering this matter, that should be, the court shall, in considering this matter, limit itself strictly to filings and only relying on links and documents filed, and no reference shall be made to public documents or public arena videos. So for better or for worse, I will only limit myself to what you have filed. Okay, so anything else? I do have to formally confirm the judgment once more, even though I gave that in an order. So quote again, as stated in previous directions, upon the conclusion, my apologies, I had mentioned something about 15 minutes highlighting. Are we still doing that? I have Wednesday available, 9:30.
Yes, my lord.
Sorry. It's been a long day. So, further highlighting, limited to those opposed who will have filed submissions on the Meru ruling on 26th of February 2025 at 9:30 a.m. 15 minutes in total. So it's 15 minutes in total.
My lord, you were under the impression that it is 15 minutes each for each of the parties.
You're too many. You're too many.
Can we do 10 minutes each then, my lord? So such that we take 3 parties, it is 30 minutes.
Then I'll dispense with the highlighting. It's too many, and I am not moving the judgment date. So I have other hightings. I took out matters today. If you go beyond that, I'll have to take out matters on Wednesday. So to strike a fair balance, you have 5 minutes, you have 5 pages, limited to 5 pages. So around 3-4 minutes each, and it'll be 3 of you because you'll be repeating each other. Maybe I can stretch you to 20 minutes, but no more than that.
We are comfortable with 20 minutes, my lord.
Yes, in total.
Yes.
In total. 20 minutes in total. Just a moment. So it will only be one side. There will be no rejoinder. That's okay? That's okay. So upon the lapse that the matter shall be reserved for judgment, and the judgment date earlier fixed is confirmed, which is Friday, 14th March 2025 at what time is convenient for yourselves?
It's a Friday, you're not.
Yes. Unfortunately, in between the time I reserved it, others snuck in their cases. So I have 3 very urgent criminal judgments on that day. Then I have 4 petition rulings, just rulings. So I'd like to do those virtually. Maybe, actually I've indicated 10:30 for those. So could I then begin at 9:30 with yours?
That's most of my.
So 9:30? 9:30? Okay. At 9:30 a.m. in open court, parties and counsel are required to be seated by 9:15 a.m. on the day. You will recall that I previously requested that you furnish me with Word versions. You still all have my email address? I can re-give it to yourselves. You will pass it. I'll only write it once, then you pass the paper. I don't want to give it out publicly. I don't want to get I don't want to get non-court related things. By Wednesday close of business, please give me your written submission. So once more, in a rush, eh? Yes.
Is it okay to maybe do a hybrid virtual physical just in case? Because I may have a commitment at time. Or I can just send counsel to online.
Yes, you can send counsel for the judgment.
Yes.
We will endeavor, it's courtroom specific, our ability to stream. So we'll endeavor to find a courtroom where I can log in and we can stream. But it is good for you to send someone just in case we're not able to. I can't guarantee which courtroom I'll be allocated on the day. So thank you very much, all of you, parties and counsel. If you require any confirmation that you are not out on a date and a judge of the High Court kept you until